Hi everyone, welcome back to the third session of Legal Tuesdays, our series looking at key legal issues arising in the film and television industries. My name is James Whitaker and I act as legal advisor to the Film and Television Charity. So in this, the final of our three sessions talking about copyright, we'll look at how copyright can be dealt with regard to third parties, and I'm talking here about selling and licensing. So let's get started. Now the first thing to recall here is what rights the copyright owner holds. The owner of a copyright has the exclusive right to do certain acts in relation to a work which others are not permitted to do. So the copyright owner can exploit or use the material. So this is relevant both in the context of protecting, using or exploiting your own work, but also if you want to use copyright protected work of another in your own project. Now a writer of a script will likely be required to assign the copyright in that script, in that screenplay, to the production company. As a matter of English law, an assignment must be in writing and must be signed by the assignor, i.e. the seller, in order for it to be effective. Secondly, as an alternative, copyright can be licensed. Now licenses are permissions, usually contractual, granted by the owner of the copyright to a third party to use the licensed material in certain specified ways and only in those ways. So if you want to license your work in which the copyright is co-owned, or if you want to license in work under a license, such as music for your project, you will likely need the written consent of all of the copyright owners. So those are the two principal ways in which copyrighted works can be dealt with. They can be sold or assigned, or they can be licensed. Let me talk briefly about a situation where licensing becomes fundamentally important, and that is the use of music in films. Under the CDPA, that is the Copyright Designs and Patents Act, for those who haven't tuned into our previous sessions, which governs copyright in the UK, the soundtrack accompanying a film is expressly included as part of the film, which means the copyright subsisting in the film will include the soundtrack. But what about using existing music? Well, any recording of music will likely attract various copyrights in itself. For example, the underlying work, any original lyrics as an original literary work, and indeed the sound recording itself. The precise assignments and licenses that you will need to use a particular piece of music in your work will depend on the nature of that music. At a minimum, you will need to license the relevant work from the appropriate rights holders, and there will likely be at least two copyrights in the work that you want to use. First, the publisher who owns the underlying work, and secondly, the record label who owns the recording. Just to complicate matters, there may also be issues around royalty payments, but the key point here is the need to obtain appropriately the copyright in the underlying work, probably through a license. And you will also likely need a synchronization license, which is the form of license that allows the soundtrack to be used in conjunction with the visual images that comprise the film. And the final thing I want to touch on today is the use of copyrighted works at film festivals and markets. Festivals, of course, unlike markets, are open to the public and can be a great way to test the audience appeal of your project, or indeed just increase awareness of your work. Either way, the organizer will still require a license from you in order to screen or display your project. And that's a wrap on today's Legal Tuesday session. I hope you found it useful. Please do join us next time where we'll take a closer look at contracts. See you then.